Hi, everyone. It's Carol Williams with Williams Immigration, and we are back for another Monday morning edition of Beyond the Soundbite, where we talk about all things U.S. immigration, what's hot, what's been going on for usually it's about the last week, but sometimes we definitely go a little bit further back if I think y'all need a quick reminder or I think it's important. And you know me, I like to dive right on in. So the first thing I have on my list of things that I want to talk to you about are USCIS has extended their flexibility in terms of time frame to respond to their notices one more time. We are still having trouble because of the pandemic obtaining documents in order to respond to some of the requests that USCIS has been sending out. And so they recognize this. So they have extended it to January 24th of next year. So January 24th of 2023. So if you have received, for instance, a request for initial evidence, a request for further evidence, a notice of intent to deny, or a notice of intent to revoke, and it was dated between March 1st of 2020 and January 24th of 2023, we are being given an extra 60 days beyond the original due date listed in that notice to respond. At this point, it definitely goes without saying, if you are able to respond without using those 60 extra days, please do so. That's only going to get your case back to being processed all that much quicker. But if you are having trouble and it's taking you a little bit of time to get some of those documents, whether those documents are coming from here in the United States or overseas, you definitely have that extra 60 days. So that is a great thing. Now, there has been a little bit of a change when we are looking at filing the Form I-290B. Usually we are using that for a notice of appeal or a motion to reopen and reconsider a case. Now the Immigration Service has said they're still going to give us more time, but they've made that time frame a little bit different. So if they have issued you a notice and the notice is dated, from November 1st of 2021 through January 24th of 2023. Only for the Form I-290B, we have up to 90 days from the date of that notice. So it's not the same extra 60 days. It is it's 90 days from the date of that notice. So just, if you have any questions about when something is due, feel free to reach out. We're certainly happy to walk you through what your extended due date looks like. The second thing I want to talk about, and it's going to be sort of a theme this morning, are backlogs, whether those backlogs be with USCIS or whether they be with the consulates overseas, or whether it's tough to get in touch with the folks at the NVC who, as we know, work in between USCIS and the consulates. So the first thing I want to talk about on that respect is that the consulates are working on their backlogs. We have heard from the Department of State, as you know, because y'all listen to me every Monday morning. The consulates are overseen and run by the Department of State. So the Department of State has come out and said that 96% of the consulates and embassies are currently interviewing applicants. As you know, during 2020, just like the rest of us and the world, the consulates were completely closed. They're only processing, super emergent cases. But now, in 2022, 96% of the consulates and embassies are, in fact, interviewing visa applicants. The Department of State has said that non-immigrant visa processing is currently at 94% of pre-pandemic rate. So that's 94% for their monthly processing rate. So that's super encouraging. They have also said that the immigrant visa processing is currently at 130% of their pre-pandemic for their monthly averages. Also lovely to see. And that between September 30th of last year, 2021, and September 30th of this year, 2022, 8 million non-immigrant visa applications were processed. Now, let me clarify. That does not mean that 8 million non-immigrant visa applications were approved. It just means that 8 million non-immigrant visa applications were processed. So I wanted to make that super clear. Waiving some of the interviews, some of the in-person interviews has definitely helped the various consulates work through their backlogs. Those waiving of interviews has freed up slots for individuals that are not eligible for interview waivers. So at this point, if you are applying for a non-immigrant visa and you're overseas, if you are eligible for interview waiver, by all means, consider taking it. I have seen processing times slashed more than in half for individuals that are eligible for having their visa interview waived versus individuals that are not. So if you are eligible for that waiver of your interview, please, please, please take it. And again, you're freeing up spots for your friends. The next thing I wanted to talk about is the Venezuelan parole program. It is live. It is running. It is a special parole program that was created for Venezuelans. It is a program that allows individuals in Venezuela to come to the U.S. So let me kind of run down sort of the big picture requirements. These are not all of the requirements, but these are the big picture requirements. Certainly, if you have any questions as to whether or not you qualify for this specific parole program, feel free to reach out to my office at 954-903-1337. We're happy to chat with you about that. So the big picture requirements for the Venezuelan parole program are that you must be outside of the United States. You must have a financial supporter in the United States. That financial supporter must be able to pass a background check. They will also have their finances checked, which is why they are your financial supporter. You as an individual from Venezuela also must pass a background check. You can bring immediate family members. Those are spouses and children under the age of 21. You cannot be a dual national with another country, have permanent resident status in another country, or have refugee status in another country in order to be eligible. So let me repeat that. You cannot be a dual national with another country, a permanent resident of another country, or hold refugee status from another country. You must have a valid passport, and you must have the financial means to purchase a commercial air flight into the United States if approved. So those are the very big picture requirements. Again, if you are not sure whether or not you qualify for the Venezuelan parole program, feel free to reach out to our office, and we're happy to have that conversation with you. I want to go back to backlogs. I kind of like to mix it up a little bit, but back to backlogs. So the Department of State is, of course, well aware that they're under tremendous backlogs. The Department of State is also well aware that certain countries are being hit by the backlogs more so than others. If you are an individual who is outside of the United States and you're currently trying to schedule a non-immigrant visa appointment in your country, the consulates in your country are severely backlogged. The Department of State is encouraging consulates to accept what we call third country nationals for visa and process their visa applications. So you become a third country national if you apply for a visa outside of your home country. Now, the Department of State is encouraging all of its consulates to accept third country nationals. What it is not doing, it is not mandating that consulates accept third country citizen applications. It is not mandating how each consulate prioritizes their specific workload. The issue sometimes with going to a country that is not your home country is one, that consulate outside of your home country may not accept you because they don't know what your documents should look like. So it is a buffer for them to ward against fraudulent applications and unknowingly accepting fraudulent documents. Whereas if you apply in your home country, those individuals that sit in your home country know what a birth certificate should look like. They know what a divorce decree should look like. They know what your utility bills will look like. They know what your utility companies are, if those are the types of evidence and documents that you are presenting during your application. So sometimes it is in fact harder to receive a visa if you are considered a third country national. So while the Department of State is encouraging all of its consulates to accept third country nationals, that is a decision that you should not make lightly. I highly recommend that before you apply for a visa in a third country, i.e. a country not your own, I would highly recommend that you have a conversation with a skilled immigration attorney who can help you weigh the pros and cons of doing that. Okay. The next thing that I want to talk to y'all about is working with the NVC. The National Visa Center is a go-between the USCIS and the consulates, all of the consulates worldwide. So as you can imagine, the NVC has a very important role when we are applying for especially immigrant visas, green card visas, or we're applying for fiancé visas. The NVC plays a pivotal role. NVC has in fact been slammed with work just like the other agencies that interact with immigrant applications. So as a result, it is sometimes taking upwards of 6 weeks when we send correspondence and questions into the NVC for them to respond. That was brought to the NVC's attention. They are aware of that. They are working to reduce that response time. They are also aware that sometimes, our clients' cases are being held up because we as counsel are waiting to get our questions answered from NVC. So we know that there are backlogs. Department of State knows that there are backlogs. USCIS knows that there are backlogs. They are all making an effort to work through the backlogs. We have seen some of the backlogs get better in certain locations for certain visas, for certain visa categories, for certain categories coming through USCIS. USCIS has worked very diligently about opening up premium processing for national interest waiver applications, as well as some multinational manager green card applications. When those applications were converted to premium process, it took them out of the regular line, and essentially we think, is starting to speed up that regular line a little bit. So we certainly are encouraging them to come up with more and more ways to help us all get through the backlog. But if you have any questions about where your case sits, the status of it, how long you have to respond to a notice of intent to deny or a request for additional evidence, and you need help with these things or anything else with your immigration applications, please feel free to reach out to our office. You can reach me at 954-903-1337, and have a wonderful rest of your Monday and a great rest of your week. And I will see you